on the motion for judicial notice, the court promised to hear and listen to the counsel for respondents either in writing or orally. I have been informed by the clerk that no responsive pleading was given by the counsel for the respondents. So I guess you will be
Your Honor, please.
orally arguing the motion.
If I may, Your Honor, please.
Beforehand, I guess you will be orally arguing on the motion for judicial notice, counsel? Attorney Christine?
We are ready, Your Honor.
Your Honor,
Again,
please.
just to hear your side. Yes, Attorney Kapunan.
At this juncture, Your Honor, I respectfully turn over to our public prosecutor and head public prosecutor, Chairman Jinky.
Yes, thank you, Honorable Luistro. Before I recognize you, Ma'am Hailin, you are excused. Sorry po. You are excused, but you are ordered, without need for the issuance of another subpoena, to appear once again before this court on August 10 and 11. 10, so in open court, you are directed to appear here once again on August 10. We will be issuing another subpoena should we require your presence again on August 11 onwards. Do you understand, ma'am?
Yes po, Your Honor.
So magpapakita po kayo sa Lunes uli nang wala ng subpoena.
Yes po, Your Honor.
Salamat po. You're excused, ma'am, and thank you for your presence and cooperation this afternoon and your patience. Now, this won't be oral arguments. The court, the chair just wanted to hear from the counsel for respondents. So really, this will not be oral arguments between the parties. Yes, what is the position of the counsel for respondent insofar as certain records of the House Good Government Committee and Public Accountability Committees, if I'm not mistaken? Attorney Christine, you'll be arguing?
Yes, Your Honor.
You may proceed, ma'am, when you're ready.
Thank you, Your Honor. The defense would like to oppose the motion for judicial notice on the following grounds. Number one, the judicial notice rule cannot be taken of disputed matters. Number two, the respondent must be given an opportunity to be heard by way of cross-examination before the court admits in evidence the matters covered by the TSNs, the video recordings, and the committee reports. And number three, the proceedings before the COJ were questioned by the respondent before the Supreme Court as a fishing expedition and mini-trial. On the first point, Your Honor, judicial notice cannot be taken of disputed matters. In Juan versus Juan, the Supreme Court defined judicial notice in this wise. Judicial notice is the cognizance of certain facts that judges may properly take and act on without proof because these facts are already known to them. Put differently, it is the assumption of a court of a fact without need of further traditional evidentiary support. The principle is based on convenience and expediency in securing and introducing evidence on matters which are not ordinarily capable of dispute and are not bona fide disputed. While the CGGPA and COJ hearings were made public, we do not dispute that, Your Honor. The matters discussed within them, which were documented via the TSNs, video recordings, and committee reports, are not facts automatically admissible in this impeachment trial. Rather, they remain assertions that must be proven by evidence. We note, Your Honor, that Article 1 of the Articles of Impeachment alleges the following: that respondent, Vice President Sara Z. Duterte, committed culpable violation of the Constitution graft and corruption, and betrayed public trust through the systematic misuse, misappropriation, and irregular liquidation of confidential funds amounting to 500 million pesos, released to the Office of the Vice President, and 112.5 million pesos released to the Department of Education. Clearly, Your Honor, these are not just statement of facts. These are accusations of misuse, misappropriation, and irregular liquidation of confidential funds which must be proven by the prosecution through presentation of evidence. In fact, Your Honor, if you noticed, the prosecution in paragraph 1 of its motion for judicial notice admitted that, I quote, prior to the transmittal of the articles of impeachment to this honorable court, the House of Representatives, through its Committee on Good Government and Public Accountability and its Committee on Justice, conducted official hearings on matters that ultimately formed the factual basis of Article 1. We highlight that, Your Honor, ultimately formed the factual basis of Article 1, which is the misuse and misappropriation of confidential funds. Okay. Article 1 of the Articles of Impeachment as a continuation. These proceedings were officially documented through transcript of stenographic notes or TSNs, official audiovisual recordings, and committee reports. I am just reading, Your Honor, I'm just referring to the motion of the prosecution. Thus, we cannot take the TSNs, the video recordings, and the committee reports as they are, Your Honor, without cross-examining the witnesses of the prosecution. The impeachment court cannot just take the utterances, testimonies, the questions and answers, and the interpellations during the COJ and the CGGPA hearings as factual findings and statements of truth without going through the usual route of evidence presentation. In fact, Your Honor, we are even unsure whether these videos are spliced, edited, or shortened, with due respect, and whether the TSNs are accurate and edited or modified as portions of the TSNs turned out to be different to our transcribed notes, which leads me, actually, Your Honor, to my second point. That because the matters covered by the pieces of evidence, Your Honor, which the prosecution would like this court to take judicial notice are exactly the matters that are being heard before this impeachment court, the respondent must be given an opportunity to be heard by way of cross-examination before the court admits in evidence the TSNs, the video recordings, and the committee reports. The requirement of due process is basic. It is the opportunity to be heard before the court, and affording the respondent the opportunity to cross-examine to cross-examine the authenticating witness serves a dual purpose, Your Honor. First, it validates the existence of the video recordings, the TSNs, and the committee report. And second, it verifies their accuracy and completeness. The Constitution explicitly guarantees the respondent's right to ensure that these pieces of evidence have not been altered, edited, or modified to fit the prosecution's narrative of Article 1. Consequently, the respondent is fully entitled to have all the observations, the objections, and cross-examination questions placed on record before the court admits these documents in evidence. It is also a matter of record, Your Honor, that the videos that the prosecution would like this court to take judicial notice were not played during the pre-trial conference, Your Honor. And it is with the understanding between the parties that there shall be subjected to proper authentication and identification during trial, consistent with the rules of court. And third, the respondent has directly challenged the House of Representatives Committee on Justice proceedings before the Supreme Court, Your Honor, characterizing them as a mere fishing expedition and an authorized mini trial, Your Honor. Consequently, the respondent declined to participate in these proceedings, maintaining that the HOR-COJ lacks the jurisdiction to conduct these trials. Under Article 9, Section 3, Paragraph 6 of the Constitution, the respondent submits that exclusive power and authority is vested solely with or in the Senate, Your Honor. That's why a petition for certiorari and prohibition was filed by the respondent before the Supreme Court. So, we cannot stipulate, Your Honor, on the matters that were taken up in a proceeding that the respondent challenged before the Supreme Court. But crucially, Your Honor, the petition pending before the Supreme Court challenges the proceedings before the HORCOJ only and not the actions of the Honorable Impeachment Court. This distinction, however, does not preclude any future legal challenges against actions that this court may take while sitting as an impeachment court. The respondent, Your Honor, was consistent in her position, Your Honor. In fact, in a letter dated March 24, 2026, the respondent through counsel informed the HORCOJ that she cannot attend the mini trial and the fishing expedition being done by the said committee because of the committee's apparent lack of authority under the Constitution. The closing paragraphs of the letter state, and I will read the closing paragraphs for the record. In light of this, while the invitation for the respondent and counsel to participate in the committee's mini trial is well noted, we cannot, however, do so at this point on the ground that the committee and/or the HOR, as well as any of its members, lack jurisdiction to conduct any form of trial or exercise any of its incidents. Absent such jurisdiction, any attempt to proceed in the nature of any form of trial or invoke powers ancillary to it is unconstitutional. Consequently, the respondent puts on record her objection to any requests, motions, or similar efforts aimed at obtaining or fishing for supposed evidence through processes that necessarily presuppose the existence of lawful authority and jurisdiction under the Constitution, which in this case is absent. As timely stated in the appearance and consolidated answer, both made ad cotellam, the respondent does not waive any jurisdictional or other objections she has to these proceedings, nor her right to seek the appropriate legal remedies. Nonetheless, she is prepared to meet the charges against her in proper jurisdiction. And because of that, Your Honor, the court must decline to take judicial notice because the very validity and authority of the House of Representatives COJ proceedings are currently challenged before the Supreme Court. Now, on closing, Your Honor, on its face, actually, the motion may look like a plea for this honorable court to take judicial notice of the purported official legislative acts described by the prosecution. However, Your Honor, if you really examine the motion, Your Honor, in reality, however, the motion is actually akin to a public prosecutor, the House of Representatives, asking the criminal court, here the impeachment court, to take judicial notice of the complaint that was filed before the fiscal, here the HORCOJ, and all matters related thereto, including those that transpired during the preliminary investigation without the need for presenting witnesses in court. That is actually what the prosecution is doing in our view, Your Honor. Dahil ang mga pandinig na ito sa House of Representatives ay siya mismong paksa ng paglilitis ng hukumang ito, at ayon mismo sa prosecution, those hearings became the factual basis for Article 1 of the Articles of Impeachment. Nararapat lamang po na ang mga TSNs, video recordings at committee reports na naglalaman ng mga tanong ng kongresista, pati na ang mga pahayag at sagot ng mga testigo ay patunayan ng prosecution sa pamamagitan ng pagpresenta ng testigo upang magpatunay sa katotohanan ng mga ito. In closing, Your Honor, would like to quote the Supreme Court in Juan versus Juan. The Supreme Court said, the article in the website cited by the RTC patently lacks a requisite for it to be of judicial notice to the court because such article is not well and authoritatively settled and is doubtful or uncertain. It must be remembered that some articles appearing in the internet or the websites are easily edited and their sources are unverifiable. Thus, sole reliance on those articles is greatly discouraged. The defense opposes the motion, Your Honor, on identical grounds. Salamat po.
Again, these are not oral arguments, counsel. Chair had anticipated the position of the council for respondent. In fact, Chair would like to clarify. The Juan versus Juan case is the Lavandera Co case, right?
Yes, Your Honor.
Ito yung Lavandera Co na kumpanya na nireklamo violating copyright standards. Hindi ba na nag-judicial notice yung korte sa isang internet website na may copyright o yan?
Tama po.
That is the case. Okay, Chair will now make its ruling. First, with respect to the motion to set the conference for marking objected to by respondents insofar as number 3 is concerned.
Number 3.
P4-35 to P4-35B, but did not object to the others. So the request for transfer of markings this afternoon, insofar as the unobjected portions are granted, insofar as the objected portions are concerned, Chair will make a ruling. We will furnish the respondent and the prosecution with a copy, with the written copy of the ruling through the journal of this court. The Chair will now resolve the panel of prosecutors' motion to set the conference for the transfer of exhibit markings, particularly on exhibits P-4-35 to P-4-35A and P-4-35B, which refer to the portions of the purported affidavit of Arturo Las Cañas. And after considering the objections of the chair of the respondent, the objection is hereby denied subject to the following guidelines and reasonings. Section 34, Rule 132 of the Rules of Court provide, the court shall consider no evidence which has not been presented or formally offered. The purpose for which the evidence is offered must be specified. Accordingly, the marking, identification, or authentication of a document does not mean that the document has been formally offered or admitted for the purpose it was so stated. The physical transfer of an exhibit, designation from a provisional copy to its corresponding original or certified true copy is even more limited. It is a mechanical and ministerial act intended only to maintain the orderly identification of the court's records. The respondent is not prejudiced by this transfer. The transfer does not alter the substance or evidentiary status of the document, referring to the Las Cañas document. It does not constitute a ruling on the authenticity, admissibility, or evidentiary weight, and it does not enlarge the purpose for which the document was originally marked. The respondent therefore loses no substantive or procedural right by reason of the transfer and may raise all appropriate objections when the document is formally offered. This conclusion is consistent with the prosecution's own representation during the July 21, 2026 hearing, wherein the Honorable Luistro stated, quote, "Your Honor, the document is being presented only to seek confirmation from the witness that he is referring to this particular document as part of the investigation of the Special Task Force. We are not presenting it to prove the truthfulness of the contents of the affidavit." Close quotation. The chair likewise previously ruled, quote, "Again, this is only as to the fact that this is what the NBI used in their open investigation and coming up with their findings, not as to the truth of the statements being read by Director Matibag." Close quotation. The chair further clarified on even date, July 21, 2026, the chair will cut short any further identifications of the witness in regard to this affidavit. This is only as to the fact that Las Cañas executed a document that they used in their open source investigation, not as to the truth of what was said. The limitations remain controlling even after the transfer of the marking of this exhibit to a certified true copy. Exhibits P-4-35, -35A, and -35B remain merely independently relevant statements only to establish that the document came to the attention of and was used by the NBI in its investigation. It may not be used as proof of the truth of the allegations stated therein. As stated in Espinelli versus People, GR number 179-535, dated 6/9/14, when the relevant fact is merely that a statement was made, the hearsay rule does not bar proof of that fact, regardless of the statement's truth or falsity. Finally, the transfer of the markings does not cure the defects already placed on the record. The purported affidavit remains unsigned, unnotarized, and not made under oath, with no witness having attested to its execution and truth of its contents. The contents of the affidavit at this time remain hearsay. The transfer of the markings notwithstanding to a certified true copy of that document. Accordingly, the clerk of the impeachment court is directed to set the requested conference as requested, I think, this afternoon, if I'm not mistaken, at 4 p.m. Now, on the motion for judicial notice, the chair will make a ruling, will grant the motion with a reminder, a stern reminder and warning. The court acting on the motion for judicial notice dated August 3, seeking judicial notice of the existence and official character of the hearings and the corresponding transcripts, audiovisual recordings, and the committee report identified therein. Section 1, Rule 129 of the rules provide, a court shall take judicial notice without need of the introduction of evidence of legislative, executive, and judicial departments of the National Government of the Philippines. As stated in CLT, the case cited by the counsel for the prosecutors, there is such referring to a Senate committee report. The court took judicial notice of the Senate committee report, but only as to the existence of the committee report and not as to the content and truth of what was stated in the committee report. Therefore, accordingly, the court grants the requested judicial notice to be taken by the court, but solely and exclusively limited to the following facts. Number 1, that the legislative hearings were actually held and under the official function of the House of Representatives, Committee on Good Government and Public Accountability, and the Committee on Justice. So to reiterate, just as to the factual existence that the hearings were indeed conducted. Number 2, that the corresponding transcripts, official, audiovisual recordings, and committee report exist as official records of the proceedings and in a separate rule, therefore enjoy the regularity of official proceedings absent contrary proof that there is either fraud, falsity, or inaccuracy, and therefore which will overcome the presumption of regularity. With a warning, having granted the motion only within the foregoing limits, the chair now states in unmistakable terms the precise effect of this ruling and reminds the prosecution, and should the time come, also the respondent, if they happen to cross this line also, Rule 129 is captioned, "What need not be proved." Therefore, the court states with precision what the prosecution need not prove, only with respect to those two things. Nothing else is judicially admitted or established. The prosecution is therefore expressly, it says warned here, but I would rather say reminded, that judicial notice shall not be used as a vehicle to place into the record substantive contents of the transcripts, recordings, or committee report. It is not a substitute for the presentation and formal offer of competent evidence, nor does it dispense with the applicable rules on authentication, hearsay, relevance, and the right of the respondent to object and confront the evidence presented against her. As the Supreme Court held in Magkamit versus IAS, PIDEA, GR number 198140, 12516, fair play requires that the respondent be given meaningful opportunity to rebut all the evidence presented against her. Therefore, consistent with the chair's prior ruling on July 21, in relation to the Las Cañas document, a witness will not hereafter be allowed to read in open court a third-party statement that is not his or her own, as the respondent would be denied the opportunity to rebut those statements and cross-examine the statements made by a third party. Again, to reiterate, the court does not take judicial notice of the truth of any statement made during the hearings, the correctness of any factual allegation, or the validity of any finding or conclusion in the committee report. those matters remain subject to proof, objection, and the court's independent evaluation of their admissibility and/or evidentiary weight at the proper time. The prosecution shall not represent expressly or impliedly that this ruling establishes the truth of any matter contained